An estate plan does more than distribute your assets after you die. Keep watching to learn the difference between estate planning and will writing. The basics. Estate planning is a broad plan for what will happen to your assets after your death. It is a complex process that involves many different processes and tools. You will detail powers of attorney, advance directives, asset distributions, trusts, and wills. You also will determine who can make end-of-life medical decisions for you in the event that you cannot do so yourself. A will is one single aspect of estate planning. A will is a single legal document that includes information such as how assets should be distributed after your death, who should care for children and dependents upon your death, who will be the executor in charge of carrying out your will's instructions. Basically, estate planning is an umbrella term that encompasses many activities. Writing a last will and testament is one of those specific activities that fall under the estate planning umbrella. Estate planning. There are multiple components of estate planning. Durable power of attorney is one of the most important. It lets you designate a trusted person like a spouse or adult child to manage your financial and legal affairs when you no longer can do so on your own. This same individual will usually also be given medical power of attorney. This means that they can make healthcare decisions for you when you're unable to do so. This is essential, even if you have an advanced healthcare directive that dictates medical decisions that you would want to make if you were terminally ill, in a coma, or facing late-stage dementia. You should also have this living will. It can alleviate stress from trusted loved ones in times of crisis and pain. You also need to designate beneficiaries for your assets. They need to be named officially so that benefits can go directly to them without the process of going through the state. If your beneficiaries are not up to date, your assets may be taxed and the beneficiaries might receive a smaller sum. Wills. To create a will appropriately, it's critical that you work with an estate planning lawyer. Wills are legal documents, so you need to make sure that you do everything perfectly. You want it to be ironclad enough to ensure that your assets can go to beneficiaries smoothly without legal disputes or taxation. Make sure that you put your name on the top of the will. Name your executor, name someone to handle your estate's probate process, distribute your property among loved ones and heirs after you pass away. Name guardians for children and adult dependents, elders, disabled people, etc. And give a caregiver for your pets. A will can also serve as a backup for a living trust. Wills and trusts. A trust goes into effect as soon as you sign the documents. In many cases, you can transfer property when you are still alive. These trusts are referred to as living trusts. The trustee can receive the assets outlined in such a document upon a certain milestone or birthday, even if you are still alive. Many living trusts are irrevocable, though some are revocable. This means that you, the grantor, can change them within your lifetime. Estate planning attorney. Johnson Turner's legal experts are committed to helping you plan your estate and transfer your property to the appropriate beneficiaries. We can help you create both will-based and trust-based estate plans depending on your individual needs. Plus, since we offer flat fee costs for firm services rather than hourly rates, you won't need to worry about hidden fees. Contact us to schedule a quick guidance call and discuss your specific needs. And if you enjoyed this video, be sure to like, comment, and subscribe.